Thank you for joining us. I'm Sister Virginia Joy with the Sisters of Life, currently serving in the Archdiocese of New York Respect Life office. I'm privileged to begin this evening's discussion with prayer. Please join me. In the name of the Father, and of the Son, and of the Holy Spirit. Most Holy Trinity, source of all goodness, truth, and beauty, we entrust our nation and the hearts of all people to you. Bring clarity and truth where there is confusion in our culture. Make our society one of true freedom, justice, and reverence for all people, including the unborn, the poor, the elderly, and the marginalized. Protect and strengthen the faith of your children. Give us courage to be authentic witnesses in the living of the gospel. Dispel all fear and give us great trust in your sovereignty. Amen. In the name of the Father, the Son, and the Holy Spirit. Amen. I am so grateful to all of our speakers for their generosity in joining us tonight with their expertise. And I want to begin by introducing Ryan Anderson, who will be facilitating our conversation. Ryan is president of the Ethics and Public Policy Center and founding editor of the Witherspoon Institute's online journal, Public Discourse. He is one of the leading Catholic intellectuals who's written extensively on how to apply Catholic social teaching and natural law to public policy issues, speaking truth with love. Ryan has been in the news recently because his book, When Harry Became Sally, which covers the scientific, medical, philosophical, and legal aspects of transgender issues, was removed from Amazon. This deserves our attention and serves as a warning about the implications of this moment. We're honored to have Ryan here with us tonight to guide our conversation about the Equality Act and why it's so dangerous for people of faith and all Americans who treasure freedom. Ryan, we thank you for your extensive research and sacrifices that you've made to give us a language and a direction as we engage these questions and concerns. And we're eager to hear from you. Thank you.
Great, thank you, Sister, and thank you to all of the groups that have organized and sponsored tonight's event. It's wonderful that so many of you can be with us tonight, and you're really in for a treat. I didn't do the organizing here, so the credit goes to Sister Joy and the others at the various dioceses and archdioceses and Catholic conferences that have put this together. I just have the pleasure to get to listen to the kind of all-star cast of legal, philosophical, and theological experts who will be speaking to you tonight. What they've asked me to do is kind of give a 30,000-foot overview of the terrain and then introduce each of our speakers. So let me just say that the challenge for Catholics is that we have to hold simultaneously various truths in our mind as we think about public policy. And the most important truth is that each and every one of us is made in the image and likeness of God. We're subjects of profound dignity and intrinsic worth, and therefore all unjust discrimination is wrong. We're also created male and female are created for each other in marriage. And so simultaneously, we need to be able to affirm in law and public policy that everyone is made in God's image and likeness, and therefore unjust discrimination is wrong, but our bodily reality as male or female isn't discriminatory. And the truth about marriage isn't discriminatory. And so the problem with the Equality Act is not that we're in favor of unjust discrimination, it's that it's overly broad in that it doesn't define what sort of actions are truly discriminatory. What the Equality Act would do is it would make acting on a true anthropology, a true vision of the human person, in many circumstances, it would treat that as if it were unjust discrimination. And so the basic argument here is that if you get human nature wrong, if you get the nature of the human person, which John Paul II taught us was the most important question of the 20th century, was about human anthropology, the nature of the creature made in God's image and likeness, that if you get the anthropology wrong in law, it's then going to cause serious harms. And in the American tradition, this comes straight out of Martin Luther King Jr., where MLK is quoting Augustine and Aquinas in his letter from the Birmingham jail, where he says that for man-made law to be just, it needs to embody the natural law and the eternal law. What the Equality Act would do is it would take a just law, the Civil Rights Act of 1964, which banned discrimination on the basis of race, and then it would add sex, sexual orientation, and gender identity everywhere where race is protected. It will expand the number of institutions that would now be classified legally as public accommodations, and it explicitly exempts itself from the Religious Freedom Restoration Act. And it's important to point out that because the word sex isn't currently a protected class in Title II of the Civil Rights Act, which governs public accommodations, and it's not a protected class in Title VI of the Civil Rights Act, which is a federal funding recipient, by making sex, sexual orientation, and gender, those titles as protected classes, and then explicitly saying that RFRA, the Religious Freedom Restoration Act, doesn't apply, the Equality Act would be affording people who believe that we are created male and female, and that male and female are created for each other, the same religious liberty protections as it does racists. All of the subsequent negative consequences follow from that. Right? If you get the nature of the human person wrong in law, then you're going to see the consequences for privacy and safety in single-sex facilities. You're going to see the consequences for equality and fairness when it comes to athletics. You're going to see the consequences for medicine when it comes to both gender dysphoria and abortion. If you get human nature wrong in law, there'll be negative consequences. And we'll have speakers this evening who will address each and every one of those points. The last thing I'll say from the 30,000 foot is that we should not be using people who suffer with gender dysphoria as political pawns. I think one of the most unfortunate things about the Equality Act and much of the political debate surrounding this is that it makes it seem like the only appropriate therapeutic medicinal response to gender dysphoria is what they call gender affirmation, puberty blocking drugs, cross-sex hormones, and then possibly surgery. People with gender dysphoria are not faking it. They didn't choose it. Imagine feeling so alien that you would contemplate taking high doses of the opposite sex's sex hormone. You would contemplate having surgery to remove various body parts. These people should have nothing but our sympathy and our compassion, and authentic compassion needs to be grounded in truth. And that's the problem here. If you create a civil rights law that will make good medicine the functional equivalent of discrimination. Thank God that we have not heard of a single case, for example, during COVID, of a hospital saying we won't give you a vaccine because you identify as LGBT. Right? If that were to happen, that would be unjust discrimination. And thank God it hasn't happened. The problem with the Equality Act is that it would take a good decision, for example, a Catholic hospital saying we don't perform elective mastectomies on high school girls who identify as boys, and it would treat that decision as if it were discriminatory. So that's what we're going to drill down on tonight, run through a variety of areas where the Equality Act, because it gets human nature wrong, causes these bad outcomes. And so I'm going to function more or less as your MC for the night. So our first speaker is going to be Robert Vega. Robert is a senior policy advisor at the U.S. Conference of Catholic Bishops, where he serves on the subcommittee for the promotion of marriage. Robert is a graduate of Harvard Law School. He spent nearly a decade working, and I first got to know Robert on the St. Joseph softball team. The Act would mean the impact it would have on Catholic institutions, such as Catholic charities, and how the public accommodation law intersects there. So Robert, over to you.
Thank you, Ryan. And thank you also to the host dioceses and state conferences for this evening's event, and good evening, everyone. I will be talking about the impact of the Equality Act on various faith-based services from the perspective of the U.S. Conference of Catholic Bishops, as well as a little bit about the broader shape of the bill. But I'd like to start with the words of Pope Francis in his 2016 Apostolic Exhortation, Amoris Laetitia, in which he wrote, quote, "Biological sex and the sociocultural role of sex, gender, can be distinguished but not separated." He continues, "It is one thing to be understanding of human weakness and the complexities of life, and another to accept ideologies that attempt to sunder what are inseparable aspects of reality." End quote. As you all know, the Catholic Church provides a vast universe of services in charities, schools, healthcare, and more. In 2020, Catholic Charities alone, which is just one piece of the puzzle and second to only the US government, helped 13 million people with disaster relief, shelter, food, wellness, including addiction recovery, asylum, employment readiness, and more. In all this, I must stress Catholic organizations serve all beneficiaries and do not deny or discriminate against any for identifying as LGBT. The Equality Act, however, would mandate how we serve others in ways that force us to either violate our faith or shut down, both of which are worse for the beneficiaries. Before getting to how it does so, we should consider a couple key sections of the bill. Section 3 deals with what is called public accommodations in the Civil Rights Act of 1964, which forbids discrimination on the basis of race, color, national origin, and religion in gas stations, theaters, restaurants, and hotels. The Equality Act takes this and does two things. First, it greatly expands the types of entities covered to now include any place of public gathering and any establishment that provides a good service or program. So virtually every consumer or charitable place or service. That would include hospitals, gyms, wedding vendors, shelters, and some argue it may even include houses of worship, religious funeral homes, and private schools. Section 3 also adds the category of sex to those that cannot be discriminated against in public accommodations. But because of the new definition of sex in Section 9 of the bill, this now includes also sexual orientation, gender identity, and various terms related to pregnancy. Now, if this were understood to simply protect someone from being denied service at a restaurant or hospital because they identify as LGBT, that may be one thing. But language like is in the Equality Act gets taken much farther than that. And as we'll see, requires others to speak or act in support of gender identities that differ from sex, and also same-sex relationships. And it overrides existing sex-separated facilities and programs. Importantly, it does not limit its reach to those with gender dysphoria, but allows anyone else to self-identify in any way at any time. Section 6 is another major section and does similarly in regulating every program or activity that receives federal funding. That would cover countless charitable organizations, health providers that take Medicare and Medicaid, schools, and other entities that partner with the federal government for the common good. So, in terms of effects under the Act, Catholic foster care and adoption, for example, would be forced to place with same-sex couples, which violates children's rights to a married mother and father, or be shut down. And we have seen this happen in several jurisdictions with similar laws. Shelters, which often protect particularly vulnerable women, would be forced to make them share sleeping and showering quarters with biological men. Again, this concern isn't about turning anyone away. It's about flexibility in how to make arrangements that are best for ensuring that everyone has a place to sleep in which they feel safe. Other social service programs, like support groups for women in crisis situations, would likewise be opened to males under the Act. Even halls attached to houses of worship, if they ever open their doors for food service to the homeless, which many do, would be forced to allow restroom access to the opposite sex, again, among vulnerable populations. And church grounds open to community events could be made to host events that conflict with their faith. In healthcare, Catholic doctors and hospitals, who will of course provide healing and life-saving care to everyone, regardless of characteristics, would now be mandated to perform gender transition procedures. And counselors would have to affirm transition rather than acceptance of one's body. At least 5 Catholic health entities have already been caught up in lawsuits under similar laws. But that's not just bad for their conscience rights. But given the increasing rate of young people experiencing gender dysphoria and the historic rates of kids otherwise resolving it with age, it's problematic to legally say to adolescents going through this pain that there are no options other than life-altering procedures anymore, as this bill does. There are also abortion mandate concerns, which Dr. Gurgas will address later. In Catholic schools, all of our universities, on account of accepting students who need federal aid, and potentially at least half of our 6,000 K-12 schools, depending on whether judged to be recipients of federal funds through student lunch or such generally beneficial programming, or on the extent of the new public accommodations expansion, they would have to align sports teams, locker rooms, dorms, sleepover field trips, and speech with gender identity. Single-sex schools might be completely out of the question. State school choice programs linked to federal discrimination law could cut out our Catholic schools. And even any schools that could maintain sports teams based on sex would still have to compete with other school teams that can't. And it's worth keeping in mind the opportunities that Catholic schools bring to kids in communities with underperforming public schools. As a side note, you may hear that the Equality Act does not touch Title IX, which famously dealt with women's sports in school. While that's technically true, the bill's amendments to the Civil Rights Act, Title VI, override that and lack all of the nuances for religion and sex-separate programming that Title IX has. You may also hear that states with similar laws have not created problems. Well, from various examples, we maintain that in many cases they have. But also, it's notable that most state laws have religious protections. The Equality Act diminishes existing religious protections. And lastly, in all of these contexts that I've discussed, no Catholic organization that hires non-Catholics is exempt under Section 7 of the bill from having to hire and retain employees who publicly contradict the faith with their sexuality-related conduct, or from having to treat them as the opposite sex in speech and facilities, or having to cover abortions, contraception, or gender transition procedures in their health plans. So you can imagine another iteration of the Little Sisters of the Poor saga, and multiplied by quite a bit. And so on that note, with all that said, I thank you all and pass it back to Ryan.
Great, thank you, Robert. That was really helpful. I want to welcome my EPPC colleague, Mary Hassan, to join us. Mary is the Kate O'Byrne Fellow at the Ethics and Public Policy Center in Washington, D.C. She directs EPPC's Catholic Women's Forum and the Person and Identity Project, which is a great resource to equip parents and educators and other institutions on how to counter gender ideology. She was a keynote speaker for the Holy See at the UN's conference last year on the status of women. And just last week, she was one of the 2 expert witnesses who testified on our side of the Senate Judiciary hearing on the Equality Act. Mary is going to speak about the harms to women that the Equality Act would create. Thank you, Mary.
Thank you, Ryan. And I'm grateful for the opportunity to address the Equality Act's impact on females, women, and girls, and to speak to all of you here, because it's so important that all of us as Catholics understand what is at stake and take the knowledge from tonight and be willing to share that with all those we encounter. So the media has given a fair amount of coverage to the fact that the Equality Act jeopardizes women's athletics, and I'll address why it threatens girls and women's sports in a few moments. But I want to begin by pointing out that even without knowing much about the Equality Act, most Americans intuitively get the idea that it's unfair to give a biological male the right to compete in and dominate female athletic competitions simply because he identifies as a girl or a woman. He's not blocked, he's not barred from competing with the males. It's because of his identity, his self-perception, that he seeks to compete with the females. From their own experience, the average person knows that there are striking differences in size, strength, and speed between most males and females, at least from puberty on. And we intuitively know it's just not fair to let males identify their way into female sports, because they will dominate and they will deprive girls of the opportunities that come with winning, the self-discipline, the achievement, the scholarships, even just making the team. I'll return to these points in a few moments, but I want to make a larger point first. The Equality Act will harm women in ways far more damaging than the losses that occur on the track, in the pool, or on the field. So if intuitively you understand that there's a problem with eliminating biological sex discrimination or distinctions in sports, be open to the fact that other aspects are far worse. And so I'll break the Equality Act's harm to women down into three categories, and I think it's a helpful way to think about it. The Equality Act compromises women's identity, our spaces, meaning our privacy and our safety, and our opportunities. First, identity. Central to our faith, supported by science, is the truth that the human person is created male or female, irrevocably so, from the moment of conception. In biology, sex has a precise meaning, the organism's overall organization towards a reproductive role. Sexual reproduction in humans occurs only between males and females, and our entire body is organized right down to the cellular level to perform that reproductive role. We're either the kinds of persons whose bodies are organized to produce ova, or we're the kinds of persons whose bodies are organized to produce sperm. So we're immutably male or female from the moment of conception. This means that my identity is female. In Catholic terms, we understand our fundamental identity in an even deeper way, as a son or daughter of the Lord. But I'm female. I'm not a gender identity. I'm a woman because I'm a female. But the Equality Act goes where no federal law has gone before. It redefines sex in a way that amounts to erasing women. The Equality Act makes no reference to the biological distinctions between male and female, even though that was the traditional understanding of sex, both when the Civil Rights Act was passed in 1964 and over 50 years later in 2020, just last year, when the Supreme Court decided the case Bostock versus Clayton County, which was an employment discrimination case, or a series of cases under Title VII. And in Bostock, although the court decided that discrimination because of sex would include discrimination because of sexual orientation or transgender status, it nevertheless noted that its decision assumed the definition of sex as biological distinctions between male and female. But under the Equality Act, there is no such assumption. There is no reference to that biological distinction at all. Instead, the Equality Act defines sex to include the following: sex stereotypes, pregnancy, childbirth or related medical conditions, sex characteristics, which means body parts, and sexual orientation or gender identity. Gender identity means your identity, your self-perception, regardless of your sex. And the Equality Act says specifically, regardless of the individual's designated sex at birth. And so here's what we need to focus on in terms of identity. Sex matters. Only females go through puberty, get pregnant, give birth, breastfeed, and go through menopause. That's biology. No one can self-define into or out of biological reality. But under the Equality Act, the law will treat a female, an actual biological female, as legally indistinguishable from a male who identifies as a female, a male who has an inner sense that he somehow is a woman. This is the privileging of gender identity over biological sex. And it has another impact as well. It changes our language. So it shifts the common meaning of words to eliminate references to females in the female body. And if the Equality Act becomes law, these terms that refer to females, are suddenly going to be terms that could precipitate a law school. Are they a lawsuit? Are they sexual harassment? Are they implying something? Are they denying someone's gender identity? As a female, I nursed 7 children, a uniquely female bond and experience. Today, lactation consultants face political pressure to replace the term breastfeeding, which refers to the female experience of a mother feeding her child from her own breast, with the term chest feeding, which is defined as the process of feeding a child human milk from a person's chest. Mothers are gone, mothers are erased, females are erased. Imagine the pressure on our culture when the law deems sex-based terms such as breastfeeding as potentially discriminatory. When gender identity is privileged over biological sex, females are erased in law, language, and culture. For what does it mean to be a woman if anyone can self-define him or herself into that category? Under the Equality Act, being female is erased. Our existence is implied and reduced to nothing more than a designated label assigned at birth. My identity as female under the Equality Act would be dissolved in the acidic bucket of gender identity. The reality of my sexed body, my female experience, would be deemed less significant, less worthy of protection than a male who perceives himself to be a woman, whatever he imagines that that might mean, regardless of his sex. So the Equality Act cements into law the ideological belief that identity is wholly self-defined, regardless of the sex body. And it suppresses the opposing belief, the reality that we're created male or female, and punishes those who would dissent, subjecting us to the risk of harassing lawsuits and judgments against us, or even just the chilling effect of not being free to be who we are, being branded implicitly with the scarlet letter B for bigot, because we're holding on to our beliefs. Second, the Equality Act eliminates the right of females to our own spaces, whether for privacy, fellowship, or safety. The Act specifically says the following, that with respect to gender identity, an individual shall not be denied access to a shared facility, including a restroom, a locker room, and a dressing room, if it's in accordance with the individual's gender identity. In other words, gender identity is the key that unlocks the door to female private spaces. So the law will forbid any public accommodation, a store, a restaurant, a public gathering space, a gym, homeless shelter, hospital rooms, from barring any male who identifies as a woman from entering these private spaces. In addition, the law also specifies that when, quote, sex is a bona fide occupational qualification, individuals are recognized in accordance with their gender identity. This means that jobs that may require intimate contact with a female body are open to any male who identifies as a woman. Think of passing through TSA and needing a pat down, or being in a theater or an airport restroom where the restroom attendants are typically female. All of those jobs then would be open to anyone who identifies as a female. The person your gym hires as a locker room attendant to hand you the towel as you're going in to shower, that is a position that would no longer be reserved to females. For young women on the cusp of their blooming womanhood, the Equality Act tells them their privacy doesn't matter. Indeed, lower court cases that challenged gender identity provisions in state and local public schools sent just this message. They denied schoolgirls the right to privacy, the right to their bathrooms, the right to their locker rooms, saying, as one court did, that it's not reasonable to be offended or to want privacy from a biological male who identifies as a girl. For women who are vulnerable, the costs are even higher. Patients in hospitals are an example. When gender identity is privileged over biological sex, that means hospitals are going to room in the women's section any male who identifies as a female. Women who are ill should not have to fear the loss of their privacy, dignity, or their safety by being forced to share a room with a male. Similarly, women who are incarcerated face increased threats. The state of Washington has already reported that there's a rise in male prisoners who are identifying as women and requesting to be moved to the female prison. We've seen the same thing, the same pattern in the UK, in Canada, where women prisoners are uniquely vulnerable to assault from these male, often sexual predators who will claim an identity as a woman and request to be transferred into those women's spaces. And again, women in shelters, domestic violence shelters, just as Robert mentioned. So finally, the third way in which women are harmed is through the loss of opportunities. And this is the one we're most familiar with. As I mentioned, biological males competing against biological females, we know what happens. Males tend to win. In fact, mediocre males can defeat the most talented female athletes. This is true at the high school sports level, as we've heard in Connecticut, where two transgender boys, two males who identified as girls, have swept more than a dozen titles, taking those spots, those accolades, scholarship potential away from the girls who have earned that. Well, that happens at the college level too. So the Equality Act threatens women's opportunities, certainly in sports, but in other ways as well. Women have long found that our ability to gather as females in women-only colleges, in girls' schools from K through grade 12, in sororities, in programs at work or special STEM programs that give women additional opportunities as women in order to help us advance. All of those things will be put at risk, subject to this category of gender identity, the privileging of gender identity over biological sex. Although US law already bans sex discrimination in education through Title IX, Title IX included careful distinctions that permitted single-sex dorms, religious colleges, fraternities, and sororities. All of that, again, would be put at risk. So by claiming gender identity as a protected category, this law would make it impossible legally to distinguish between a female and a biological male who claims to be a woman. The law thus tells us females that not only does our privacy not matter, but our safety doesn't matter either. Because of our biology, women are uniquely vulnerable to sexual assault. So when people ask you, why do you oppose the Equality Act? We can share from the heart that we care that people are treated fairly and that unjust discrimination is not permitted. But that's not what the Equality Act does. To the contrary, it treats civil rights as a zero-sum game, that in order to ensure no unjust discrimination for persons who identify as LGBT, the law must strip females, people of faith, from their civil rights, and for females, erasing our identity under the law, erasing our identity, erasing our spaces, and erasing our opportunities. So when the law privileges gender identity over biological sex, females lose. It's that simple. Over to you, Ryan.
Great. Thank you, Mary. That was outstanding. Next, we're going to be joined by Dr. Gabrielle Gurgas. Gabby is a new colleague of mine at the Ethics and Public Policy Center, where she is one of our inaugural postdoctoral fellows. And that postdoctoral part means that she has recently successfully completed her doctoral degree at Princeton University, where she wrote her dissertation on the philosophical foundations of American religious liberty law and why religious liberty deserves to have special constitutional protection. Gabby was an undergrad at Notre Dame, did her PhD at Princeton, and now she's a postdoc at EPPC. She's going to be focusing on the religious liberty implications for the Equality Act, especially as applied to abortion and conscience. Thank you, Gabby.
Thank you so much, Ryan, and thank you also to Sister Joy and to Amy McInerney and the other organizers of tonight's event. It's really a joy and an honor for me to be able to speak to you, especially alongside such senior and more established colleagues. I'm actually going to start on a note, similar notes to Mary, and just preface what I'm going to say tonight about the religious liberty implications of the Equality Act with an appeal to some of the younger people who might be listening to this and who are feeling on the fence about opposing the Equality Act, which at least in name sounds like a law that everyone should be willing to support. And what I would say to you is that, just as Mary said, and as Ryan said at the beginning, it's always right to oppose unjust discrimination against people who are equal in dignity to everyone else and who need our compassion and our love. The Catechism tells us that. And no one here is in favor of unjust discrimination against people who identify as gay or trans or against anyone else. But the Equality Act, as I'll talk about and as others are emphasizing tonight, sweeps far more broadly than that. And much of its effect will be not to help people in need, but to do harm to legitimate freedoms of association, expression, and religion, freedoms that have been protected from the founding of our country and are written into our very Constitution. And those are what I want to talk to you about tonight. And what I will say will have two parts. First, I'm going to talk briefly about why the Equality Act is so overbroad and really extreme from a religious liberty standpoint. And then second, I'll talk about some of the ways that the Equality Act might affect you day to day and the way that you exercise your religious liberty, and with particular attention to the issue of abortion. So first, what makes this law so overbroad? The Equality Act is a radical piece of legislation in two ways, both in the scope of the issues that it covers and in the breadth of the application that it will have. First, on the scope, I think the best way to think about the Equality Act is as one giant law that covers many of the religious liberty challenges that we've seen in the last decade. Challenges, say, for example, to bakers, artists, florists, photographers who have been forced to serve same-sex weddings, religious business owners who've been forced to provide insurance coverage for contraceptives that cause early abortion, religious adoption or foster care agencies that have been unwilling to certify same-sex couples as potential foster parents or adoptive parents because they believe that children deserve a mother and a father. The Equality Act says that in any of these kinds of cases, we can no longer claim a religious liberty defense. And it does that, as Ryan and Robert have mentioned, by explicitly prohibiting any appeal to the Religious Freedom Restoration Act. And I'd like to talk just briefly about RFRA, as it's called, just because it's worth knowing what this law does and why it matters so much that the Equality Act is just putting it completely under the table. RFRA passed with bipartisan support in 1993, and it's a law that requires religious exemptions from federal regulations of all kinds, unless the state has the strongest possible justification for those policies. And it has been tremendously important to religious people who have been seeking to protect their freedom to live out their vocations in the public square. But the Equality Act is the very first federal regulation to exempt itself from RFRA. It takes away our ability to appeal to RFRA in all the cases over the last decade where it's been cited before. So in that respect, it is certainly the biggest and the most aggressive effort so far to push traditional religious believers out of the public square. The Equality Act will also have the broadest application of any anti-discrimination policy so far because it will apply all across the country in every state. And the law also drastically expands, as Robert already explained, the meaning of a public accommodation beyond the few categories of places that are covered by the original Civil Rights Act of 1964. Under the Equality Act, pretty much any public space you can think of, whether it's physical or virtual, will be a form of public accommodation, and so it'll be liable to the provisions of the law. And also, it's worth saying the Equality Act is like other federal anti-discrimination laws, and that it will apply to any entity that will receive federal funding. Now, turning to the second half of what I want to talk to you about, which are just some of the practical upshots of the Equality Act that you should be aware of, ways that it might affect you in day-to-day life. And I'll start with the issue of abortion, since I've been asked to focus on that. As others have already mentioned tonight, the Equality Act adds sexual orientation and gender identity to the protected class of sex in the Civil Rights Act. But it also expands the meaning of sex to cover pregnancy, childbirth, or a related medical condition. And under the Equality Act, all federal and state healthcare programs and any healthcare programs that receive federal funding must provide access to all treatments for the condition of pregnancy. But what's interesting to note is that federal law already bans discrimination against pregnant mothers. So what the law is really doing is, as what it really means, as pro-life leader Lila Rose has put it, is that we now have to treat the decision to end a pregnancy exactly the same as the decision to sustain a pregnancy. So, and the short of it is that if you work in the healthcare industry at all and you don't want to refer for, participate in, or perform or support an abortion in any way, which is a reasonable judgment of conscience and has been previously protected in the law, you can now be sued under the Equality Act for pregnancy discrimination. And another effect the Equality Act has in this area is that it also effectively repeals the Hyde Amendment, which prohibits federal funding or taxpayer funding of elective abortions. Other federal anti-discrimination laws have amendments clarifying that non-discrimination does not mean that you have to cover, provide, or participate in abortions. But the Equality Act noticeably lacks any amendment like that. So it will almost certainly be read to repeal the Hyde Amendment. Moving on to another area of healthcare, which is that the law will penalize any medical providers who refuse to perform gender reassignment procedures based on the reasonable and science-based judgment that those procedures are deeply harmful. It is worth reiterating, again, as Brian said at the beginning, that we don't know of a single Catholic hospital that has refused to treat a patient because he or she identifies as gay or trans. And that would be true and just discrimination, and it would be an outrage that we would all be talking about if that had happened, and rightly so. But we do know of hospitals that have refused to perform reassignment procedures or abortions, and the law just bakes in the assumption that those reasonable judgments are unjust discrimination. It just takes any discussion on that question off the table completely. Others have already talked about the religious liberty implications for public accommodations, including wedding service providers. So I will just pass on further discussion of that. But I just want to move on to the last point I would make, which is that religious institutions will certainly be subject to the provisions of this law. And it's really important to know that if your children's religious schools or colleges, if they attend those, or if you're employed by one of them, they will not be exempt from these requirements, especially if they receive any kind of federal funding. The Equality Act is going to sanction them for teaching mainstream biblical views about sex and biology, for maintaining sex-segregated facilities or sports teams or extracurricular activities, as Mary already discussed. And I think on this point, I want to take the opportunity to address another concern that some people might have, which is whether churches under this law will keep their tax-exempt status. And I'm also going to just briefly address the response that some Democratic senators have given to those who are concerned about the Equality Act, that our concerns are just scaremongering and that there isn't really going to be any change to what we believe or how we worship. So first, on the tax-exempt status of churches, this is something that's not directly addressed by the law. That's a decision for Congress and the IRS to make. But what's important to know is that the Equality Act lays the cultural foundation for that, for taking away that status. Because, as Brian has already pointed out, it makes any church that teaches that we are created male and female, and that male and female are created for each other, the legal equivalent of racists. And years ago, the IRS took away the tax-exempt status of Bob Jones University, which had banned interracial marriage among its students. And the Supreme Court then upheld that decision because on the grounds that the federal government had such a pervasive policy against racism. So there's certainly precedent in the law for taking away that status. And I think it's not unreasonable to think that would happen. And then lastly, I think it's really important to come back strong against some of you may have received letters from your Democratic senators reassuring you that your religious beliefs won't be affected or need to be changed in any way based on, if the Equality Act is passed. And their responses so far have been really disappointingly weak because they've overlooked a fundamental fact about religion, which is that religious exercise is not just a matter of belief or worship, it's about our action in the public square. Sure, this law might leave you free to believe what you want within the four walls of your house or your church, but as soon as you step out into public life and you try to live out your vocation as someone who provides many social services that religious people are motivated to offer, healthcare, education, adoption, working in soup kitchens, as soon as you do that, you will be liable to all of the provisions of the Equality Act because it extends the range of public accommodations so far, so much farther than any previous existing anti-discrimination law. And so I'll just close by driving home one final point about why this law, at least from a religious liberties perspective, is so egregious. It's unjust for many reasons, but one of the most important ones is that it bakes in a lot of assumptions, but one of the most radical assumptions is that we should all be required to shoulder the costs of one person deciding to identify as a member of the opposite sex, but we should have to shoulder none of the costs that come with living our faith publicly. The Equality Act insists on the one hand that girls can no longer have private locker rooms or female healthcare providers, while maintaining that traditional Christians can no longer be doctors, teachers, or wedding service providers. And that should truly be outrageous to all of us and worth writing to our senators about, not just because it's deeply unjust, but because religious people have always helped the state shoulder its burden of care for its citizens through all their valuable work in education and healthcare and all the other ways that we've already talked about tonight. And the state in turn has always protected that invaluable service it's always supported that and rewarded that by protecting religious liberty. And so the Equality Act just completely destroys that mutually beneficial relationship we've always had between religion and the state. And in the process, it will leave our cultural landscape completely unrecognizable. So once again, I'd really like to urge you to spread the word, to do what you can to oppose this law. And that's all I have to say. So thank you very much. And back to you, Ryan.
Great. Thank you, Gabby. That was wonderful. Thank you. Next up, we're going to hear from Susan Muscat. Susan is the president of ProFamilyWoman.org. She's an attorney who spent much of her career working to enact pro-life laws in the US Congress, including she served as senior legislative counsel for the National Right to Life Committee. She's a graduate of Georgetown University. She received her law degree from the University of Notre Dame Law School. And she'll be speaking to us tonight on the impact of the Equality Act on public schools and parental rights. Over to you, Susan.
Thank you, Ryan. In my opinion, one of the most serious impacts of the Equality Act is going to be its impact on children. And I'm going to focus on its impact on children in our public schools. Now, keep in mind, as I discuss this, that if this bill passes, this will be a national law affecting every public school in America, including elementary schools down to kindergarten age. So let's begin with the school bathrooms. The Equality Act will require federally funded public schools, which is all public schools, to allow students access to restrooms, locker rooms, group showers, and sports based on the student's asserted gender identity. And this will apply nationwide. And a school cannot prevent a transgender student from accessing these facilities so long as he or she asserts a gender identity that is compatible with the sex of that segregated area. This is what will be required of every public school if the Equality Act becomes law. This change in school policy would compromise the privacy of students and could create discord in the school community. Now, transgender students will likely be the sole arbiters of their transgender status because the Equality Act provides no guidance for schools. So it will likely be the students' unilateral assertion of their gender identity that will be the controlling criteria, and that will set in motion all of these requirements regarding the proper treatment of transgender students. The Equality Act will also likely impact the teachers in our public schools. The Act's prohibition on discrimination based on gender identity will likely mean that public school teachers will be required to address transgender students by their new name and chosen pronouns, even if it violates a teacher's religious beliefs. If a teacher doesn't do so, it will likely be grounds for disciplinary action. That means that Christian public school teachers could be fired for refusing to lie about a child's sex. This has already happened in Virginia. A high school teacher was fired because he could not in good conscience use male pronouns to refer to a biological girl who identified as a male. The teacher did address the student with the student's chosen new masculine name. But according to the teacher's attorney, the teacher was given an ultimatum: either affirmatively use male pronouns when referring to the student or be fired. Next, although it is not explicit in the Equality Act, there is an underlying presumption in the Act that the only way to address a child's gender dysphoria is to affirm the child's new gender identity. And this means that parents could be placed at risk of being reported by school personnel to a child protection agency if they are not affirming. If those parents are not affirming of their child's new gender identity, it could be construed by school personnel that the parents are not acting in the best interest of the child. And lastly, if the implementation of the Equality Act follows the path of the implementation of the Civil Rights Act, then the public school curriculum itself could promote gender identity ideology with little opportunity for parental opt-out. 10 states currently have laws prohibiting sexual orientation and gender identity in school curriculum. But if the Equality Act becomes law, those state laws could be overridden. So the bottom line is that the Judeo-Christian belief that God created us as male and female will be undermined throughout the entire public school system. Just think of those innocent children being bombarded at their school with gender theory. Many more children may become confused about their own gender identity. I've been talking about public schools, but no doubt, if it becomes law, activists will use the Equality Act to go after federally funded private schools, whose lawyers will be kept very busy in court trying to protect the school's rights. Now, I want to address parental rights. I've already touched on how parental rights will be placed at risk in the public schools. But of equally serious concern is the impact the Equality Act could have on the rights of parents to control certain medical treatments for their children. For children experiencing gender dysphoria, there are mental health counselors who work with children to help them become comfortable with their biological sex. But if the Equality Act passes, parents may not be able to find a mental health counselor who could help a child accept their biological sex. It is likely that the Act's prohibition on discrimination in healthcare based on gender identity will result in mental health counselors being required to affirm a child's transition to a new gender identity. And so the only mental health counselors that a parent might be able to find will likely be those that will affirm a child's transition to a new gender identity. Now that's with regard to mental health. Regarding the actual physical treatment of a child who is experiencing gender dysphoria, there's an underlying assumption in the Act's non-discrimination in healthcare provision that puberty blockers, cross-sex hormones, and surgery transition are standard treatment. And if it is viewed as the standard medical treatment, if a parent declines these treatments, their child could potentially be taken away from them by the state. That has already happened in a case in Ohio, which Gregory Baylor is going to address next. And so it can be expected that the Equality Act will pit parents against children. And what's especially sad is that we are talking about potentially pitting parents against minor children who likely don't even comprehend the life-altering consequences of taking puberty blockers or cross-sex hormones. I think of that British girl, Cara Bell, who was given puberty blockers at 16, testosterone at 17, and a double mastectomy at 20 in her transition to a new identity as a male. She came to regret her transition, later telling a court, "I started to just see a woman with a beard, which is what I am." Thank you, and we have more resources regarding this aspect on our website, profamilywomen.org. Back to you, Ryan.
Thank you, Susan. That was great. Next, I want to welcome Greg Baylor. Greg is the director of the Center for Religious Schools at Alliance Defending Freedom. He also serves as the Senior Counsel for Government Affairs at ADF, focusing on Congress and federal agencies. He's a graduate of Dartmouth College and of Duke's Law School. Greg is going to play kind of cleanup batter, I guess, here, because he's going to fill in anything that remains to be said, with a particular focus on some of the stories, real life individuals who have been harmed by these sorts of laws in other states where they've been passed. ADF is a wonderful law firm that has been representing many individuals who have been victimized by these sorts of policies. And so I'm just going to turn it over to Greg to share some of those thoughts with us.
Great. Well, thank you, Ryan. And I also want to extend my gratitude to the organizers of this really important event. It's honestly quite a privilege to have been invited to participate. I also wanted to thank all the other speakers for their wonderful and informative presentations. You know, throughout the presentations, we've been hearing about the negative impacts that the Equality Act will inflict upon the American people if that bill becomes law. And one of the reasons we don't need to speculate about what the Equality Act would do is because lots of jurisdictions at the state level, the local level, and the school district level have adopted policies similar to the Equality Act, similar in how they ban gender identity and sexual orientation non-discrimination, and how they neglect to adequately account for those who dissent from the emerging sexual orthodoxy. I'd like to share some of the stories that have come about because of the existence of such policies and laws at the state and local levels. Alliance Defending Freedom, my organization, not only attempts to influence members of Congress and their staffs about things like the Equality Act, we also have the great privilege of representing clients in litigation. So although I didn't personally represent very many of these individuals and organizations, it is firsthand information about the harms that will come about if we have something like the Equality Act at the federal level. ADF represents a nonprofit religious organization called the Downtown Hope Center in Anchorage, Alaska. This is an organization that helps the homeless, feeds the homeless, teaches the homeless, and its services are open to both men and women throughout the day. At nighttime, however, the Downtown Hope Center does create a safe space for women and only women to sleep. Many of those who are housed at the Downtown Hope Center overnight are women who've been victims of domestic violence, other abuse, or trafficking. So you can understand why, given its limited space and given the need in the community, the Downtown Hope Center decided to reserve its communal sleeping space just for women. One night in Anchorage, a man who identifies as a woman appeared at the front door of the Downtown Hope Center. He was intoxicated, he was injured and bleeding, and he asked to sleep overnight in the Downtown Hope Center. Now, they didn't just turn him away. They responded in compassion, and they offered to take him to a hospital for treatment. They offered to transport him to a men's shelter where he could comfortably stay. And he declined both of those things. What he did instead was to go to the city of Anchorage and essentially file a lawsuit or file a complaint against the Downtown Hope Center. Under what law did he do this? Well, he did it under a law that's similar to the Equality Act. The Equality Act, if it passes, would outlaw sexual orientation, gender identity discrimination in, quote, places of public accommodation. As Robert Vega from USCCB mentioned in his presentation, one of the things the Equality Act does is to dramatically expand the definition of what counts as a place of public accommodation. And I guess Anchorage's definition of that term was broad enough in its ordinance to reach, at least they thought, a shelter like the Downtown Hope Center. So he claimed he was discriminated on the basis of gender identity because the shelter reserves its communal sleeping space for biological men. In the course of defending Downtown Hope Center in this case, it came out that the feelings of the women who were staying there. And one of them remarked, I thought quite poignantly, she said that if she were forced to sleep, and again, this is a communal space where the cots are 3, 4, 5 feet apart, that if she were forced to sleep in a space like that with biological males present, that she would rather sleep outside in the cold Alaska winter than to do that. So again, the Downtown Hope Center doesn't just serve women, but it reserves its sleeping space for women. Now, fortunately, they prevailed in their case. We were able to persuade the adjudicator that the Downtown Hope Center is not a so-called place of public accommodation. The problem is this: if the Equality Act passes, its definition of place of public accommodation is much broader. It explicitly includes shelters. There is an intent on the part of the drafters to reach nonprofit organizations, including food banks, on shelters. So the Downtown Hope Center would not be able to escape liability and prosecution under the Equality Act were it to become law. The other way that that scenario would be nationalized through the Equality Act is through the Equality Act's amendment to Title VI, which is that piece of the Civil Rights Act that attaches a non-discrimination string to federal financial assistance. Now, the Downtown Hope Center doesn't take federal money, but lots and lots of homeless shelters, gospel rescue missions, and the like do take federal money. And if the Equality Act becomes law, they would become subject to a rule like the one that the Hope Center got in trouble with. Creative professionals. You've probably read in the news about the cases involving typically Christian creative professionals who come into conflict with a state law or an ordinance that forbids sexual orientation and gender identity discrimination. Again, if the Equality Act passes, this is something we're going to see proliferate and be magnified and be found all over the entire country. ADF has had the privilege of representing a handful of these creative professionals in their conflicts with these Equality Act-like ordinances. We represent Jack Phillips, who is a cake artist in the Denver area of Colorado. He serves everyone, but he can't create every message. Everyone who walks through the door, he is willing to serve. But some people request custom cakes that communicate messages that celebrate events that he, as a matter of conscience, as a matter of his religious conviction, cannot be part of. Prior to the incident that led to his case, that led all the way to the Supreme Court, he had turned down business to create cakes that celebrated things that he was opposed to. He even turned down a cake that had an anti-LGBTQ message on it. But one day when someone came into his shop and asked him to create a cake that would be used to celebrate a same-sex wedding ceremony, he respectfully declined because of his conscience. And needless to say, there were countless other bakeries nearby that were willing to provide a suitable cake for the same-sex couple that wished to be married. In fact, the other bakery did it for free. But that wasn't enough. It became necessary in the eyes of some to go after Jack, to punish him, as it were, for his sin. And he was charged with committing sexual orientation discrimination under a state law that bans discrimination, again, in places of public accommodation. You may have heard that his case went all the way to the Supreme Court, and he prevailed. It was a relatively narrow basis. It was based on the animus of the adjudicators, the religious hostility and bigotry that they showed. The court said that he just didn't get a fair shake because of that. But the point of the story is we're going to see more and more of that if the Equality Act becomes law. Similar story out of Washington State. ADF represents Baronelle Stutzman, who runs and has run Arlene's Florist for many years. She had a lot of relationships with recurrent customers, including a man named Rob Ingersoll. For almost 10 years, she had been serving his needs. They had become friends over time, chatting every time he came into the store. She was aware that Rob identified as a gay man, and that made no difference to her whatsoever when she was either interacting with him as a friend or selling him flowers for the various life events that he wanted flowers for. But he came in one day and he said that he was marrying his partner and he wanted Baronel to provide the flowers for the wedding service. And she told him that she couldn't do that because of her relationship with God. And he seemed to be very understanding about that and understood who she was and where she was coming from. And he probably understood that there would be plenty of other florists willing to help him celebrate his same-sex wedding. However, news of this encounter became public. The Attorney General of the state actually read about it on a social media post and decided, like Jack, that Baronel had to be punished. So he commenced litigation against her, and not only going after her business, but going after her and her personal assets as well. That case continues on. We've asserted First Amendment defenses, but I think Baronel would prefer if she hadn't been sued in the first place. And again, the problem with the Equality Act is that if it's passed, we'll have this sort of scenario, not just in some states like Colorado and Washington, but in many, many others. You know, the gender ideology is starting to creep its way into custody disputes, disputes about who should have care and possession, as it were, of children. Susan mentioned a case out of Ohio. I'm not going to say much more about it than she did, but there was a situation where there was a troubled young girl, and she was struggling with her gender identity. Her grandparents kind of got involved in the mix, and that at some point she ended up staying with them. They were very much in favor of treating her alleged gender dysphoria with cross-sex hormones and potentially surgery down the line, but her biological parents were not. They did not think that that was the best course of action for their daughter, both socially transitioning and as a matter of kind of good medical judgment. It's a complicated case, but it's definitely true that when the judge was making a decision about awarding more permanent custody to the grandparents, that the parents' unwillingness to consent to the provision of cross-sex hormones to their daughter played a role and undermined their position, undermined their ability to get their daughter back. And the Equality Act would not directly dictate this result, but it certainly, its mindset, its underlying ideology would point in that direction and probably encourage the proliferation of situations like that. A number of the presenters have mentioned the situation involving female athletes who are forced to compete against males who have, particularly following puberty, undeniable biological advantages. ADF represents a number of female high school athletes in the state of Connecticut. All of them are track runners. All of them are elite. All of them work very hard every day to shave hundreds and tenths of seconds off their personal bests because they want to compete, because they want to win, they want to advance, they want opportunities for scholarships. As these girls approached their junior and senior years in high school, there were two young men who began identifying as girls and started competing in their races. This was because the Connecticut Interscholastic Athletic Association said that it would be discriminatory to exclude boys who identify as girls. These boys did not do anything even to attempt to diminish the physiological advantages they have just from being male. These two boys alone have captured almost 20 state titles in Connecticut since they started competing in the girls category. They have robbed female athletes of approximately 85 opportunities to advance to higher level competition, including competition where scouts are attending, scouts from colleges who might be willing and able to afford them scholarships. We're continuing to litigate that case, but I think the Equality Act, again, would recreate this problem nationwide. As Robert mentioned, it's not so much because it amends Title IX, the statute that we think of when we think of women's athletics, but because it amends Title VI, which, like Title IX, is a non-discrimination string that attaches itself to federal money. So we can expect to see much, much more of that nationwide if the Equality Act becomes law. The last story I'd like to tell involves religious education. The state of Maryland has a school choice program, the Opportunity Scholarship Program. Like most school choice programs, it's focused on individuals with financial needs who come from disadvantaged circumstances, who customarily would not be able to afford a private school. And it customarily benefits students who are in public school districts that are underperforming. We represent Bethel Christian Ministries outside Baltimore, between Baltimore and Washington, D.C. They've been a participant in the scholarship program. They have never, not once, turned away an applicant for any so-called discriminatory reason, whether it's the religious convictions, the beliefs of them or their parents, whether there's sexual orientation or gender identity. And they told the state that they would not turn away students because they identified as homosexual or transgender. But nonetheless, simply because the school had in its policies a statement that it believes in the traditional understanding of marriage as one man and one woman, that it believes in the distinction between the sexes, that God created them male and female. For that reason alone, the state of Maryland not only withdrew their funding, but also demanded that they pay back over $100,000 in funds that they had already received. This is the sort of outcome that we will probably see under the Equality Act if it becomes law. First, it's possible, even probable, that schools will be deemed places of public accommodation. And I think it's important to understand that, because every time we say that, what we're saying is this entity that's deemed a place of public accommodation can be regulated even if it doesn't get money from the government. So you can't avoid these problems. We're saying, well, I'll just give up the federal financial assistance. I'll only accept students that don't have federal. No, that is not going to be a workaround to the problems that the Equality Act created. So again, the case is still in litigation and we're hoping for a successful outcome. But what I don't want to see is again, a repeat of this in every state in the union. Again, we don't need to speculate about what the Equality Act will do. We've seen what analogous laws at the state and local level do. And along with Gabby, I encourage you in the strongest terms possible to communicate your views about the Equality Act to your elected representatives in Washington. And with that, I will turn it back to Ryan.
Great. Thank you, Greg. That was really helpful. And I hope for the people viewing this at home, you see just the litany of people who have already been harmed by these sorts of laws at the state, local, and school district level. Let me just say a few words by closing before I turn it back over to Sister Joy. I just want to encourage everyone to exercise your duties of faithful citizenship. First, if you want to learn more about the Equality Act, about these issues, the dioceses and archdioceses and Catholic conferences that have sponsored this event, they've created a landing page at humanlifeaction.org where you can read more about this issue, what the bishops are saying, what the USCCB is saying. You can also go to profamilywoman.org to learn more, go to adflegal.org to learn more, eppc.org, and personandidentity.com. So if you're looking to read up more about this, that's step one, faithful citizenship. Put in the time to study, to learn. Step two, speak out about this. Consider contacting your elected official directly. Consider writing a letter to the editor. If you don't think you're a good writer, consider sharing someone else's letter to the editor or an op-ed on your social media page. Tweet out an op-ed on this issue. Share on Facebook an op-ed on this issue. Share the bishop's statement on this issue. And then lastly, pray. A part of faithful citizenship is praying for our elected representatives. Pray for those who support the Equality Act because they haven't heard all of the reasons to not be supportive of this. Pray for those who experience the truth about human sexuality as a particular cross that they bear. Pray for people who struggle with gender dysphoria, that they'll receive the care that they deserve to feel comfortable in their own bodies. And with that, I'm going to turn it back over to Sister Joy to close us out tonight.
Thank you so much, Ryan. Thank you to all of our speakers, Mary, Gabby, Susan, Robert, and Greg. We're so grateful to each of you for your presence here tonight and your leadership in these efforts. Thank you to all of you who are joining us. We know that you received a lot of information. I hope that you will take those 3 steps that Ryan has said in terms of faithful citizenship, contacting your legislators by going to humanlifeaction.org and the many other sites where you can contact your legislators, and through prayer. It is clear the Equality Act does not support the flourishing of the human person or the common good. And we really do hope that you will share this information, that you will talk about it with others after tonight. As we close, I think of the words of St. Paul to the Corinthians. We do not lose heart. Certainly we are united in taking action, and more importantly, we're united in prayer. May the Holy Spirit transform our own hearts and transform the hearts of those in this nation. So as we close, we pray, glory be to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. In the name of the Father, the Son, the Holy Spirit. Amen. God bless you all, and good night.